The knock wasn't loud, it was measured, like whoever was on the other side expected the door to open because it had to, not because I wanted it to. I looked through the peephole and saw a man in a navy windbreaker with a county seal on the chest. Behind him, half a step back, a second man held a clipboard and a padded envelope. They weren't standing like salesmen, they were standing like a deadline. When I opened the door, the first man introduced himself as a process server contracted for the county. He said my name, the way you say something you've already verified. Then he asked for confirmation of my identity. I gave it. He handed me the envelope and waited while I looked at the front page through the transparent window. Notice of hearing, emergency motion, probate division. The date was that same day, the time was 11 a.m. I looked at my watch, it was 8:16. The server didn't explain what the hearing was, he didn't need to, the first paragraph did. It said that my brother Daniel had filed an emergency motion alleging that I was wrongfully withholding estate property, obstructing administration, and threatening irreparable harm by refusing to surrender items belonging to the decedent. The decedent was our mother. She had been dead for 6 months. The document was stamped and signed. There were attachments. One was an affidavit by Daniel. The other was an order to show cause, already set for that morning. It told me to appear and explain why I should not be held in contempt. There are a lot of ways to absorb a lie. Some people get hot, some people shake. I didn't do either. My body did what it always does when something becomes procedural. It narrowed down to tasks. I asked the server if there was anything else. He said no, and he made a small note on his clipboard while his partner watched my face with the detached interest of someone paid to notice when things change. Then they left without another word. When the door closed, I placed the envelope on the kitchen table and looked at the calendar on the wall. I still had my mother's handwriting in the corner. Call Daniel. It was written in ink from 2 months before she died, when she still believed he would answer. I sat down and read every page. Daniel was claiming I had the contents of a safe deposit box he had supposedly discovered after her death. He claimed the estate was missing jewelry, cash, and a binder containing trust instruments. He said I had refused to provide him with access despite his authority as personal representative. That was the first betrayal, because it wasn't just that he was lying about what I had, he was lying about what he was. Daniel was not personal representative. I was. The court had appointed me after he failed to show up to the initial probate hearing. Twice. He had signed the waiver of notice and then ignored the calls. He'd told me at the time that he didn't want anything to do with it, that I should handle Mom's paperwork like I always did. Now he was standing up in a sworn affidavit saying he had authority, and I was the obstacle. The second betrayal was more specific. His affidavit said I had taken possession of estate property from the decedent's residence 2 days after her death, without notice and in violation of the decedent's expressed wishes that Daniel oversee distribution. My mother had never said that. She'd said the opposite, in writing, in a letter dated 3 years earlier that she'd given me in a sealed envelope with instructions not to open it unless something happened. Something happened. I stood up and went to the cabinet above the refrigerator. I pulled down the metal cash box where I kept the estate documents. It wasn't locked because I didn't need it locked. I needed it organized. Letters testamentary, inventory filed with the court. A complete list of assets known at the time. Bank account statements. Mail forwarding confirmation. The initial petition with Daniel's address listed and his signature on the waiver. I grabbed my phone and opened my call log. I called Daniel 12 times during the first month after Mom died. Then I stopped calling. Not because I gave up, but because at some point you need your record to show that you tried, and then proceeded without the theatrics. I turned to the last pages of his filing. Attached was a proposed order asking the judge to compel me to surrender all estate property, to grant him access to all accounts, and to restrain me from transferring anything. A freeze order, that was the threat hiding inside the accusation. It wasn't about jewelry, it was about control. I looked again at the time. 8:29. The hearing was in 2.5 hours. I called the courthouse clerk. I gave my case number. The clerk confirmed an emergency hearing had been scheduled because Daniel's attorney had requested an immediate order to prevent dissipation of assets. The clerk told me the judge would hear it as a matter of priority. I asked if my filings were accessible to the judge. The clerk said yes, everything was in the docket, but that it would be helpful if I brought hard copies. I told her I would. Then I called Daniel. It rang until voicemail. His voicemail message was old. It still had our mother's name in it, recorded years ago when he lived in her basement and couldn't be bothered to set up his own line properly. I didn't leave a message. I didn't need my voice on his record. I needed his silence on mine. I called the attorney listed on the motion. The receptionist asked my name. I gave it. She asked if I was a client. I said no. There was a pause. Then she said the attorney was unavailable but could take a message. I said I would be in court at 11 and that I'd be filing a response with exhibits. I asked her to note that Daniel's affidavit contained false statements about his legal status. Her tone changed slightly, not softer but more attentive. She said she would pass that along. I ended the call. I opened a folder on my laptop labeled Estate Court. Inside were scans of everything I'd filed. I printed the letters testamentary first, because authority is the door you walk through before you argue about anything else. Then I printed my inventory. My inventory was honest. It listed our mother's checking account, her small savings account, her car, and her personal effects at the apartment. It listed the few pieces of jewelry I knew about, valued modestly, because they were modest. It listed the furniture, valued nominally. It listed the life insurance proceeds that had already been paid directly to the named beneficiary. Me. Daniel's motion didn't mention the life insurance. It wasn't part of the estate. That was the point. He didn't care about probate accuracy. He cared about leverage. But his motion did mention a safe deposit box. That was the first time the phrase appeared in any document with his name on it. Because the safe deposit box wasn't real. At least not in the way he claimed. There was a safe deposit box. Mom had rented 1 year earlier, then closed it. I had the closure letter. I had the final payment receipt. The bank had told me, in writing, that the box was closed and empty, so why was Daniel inventing it now? The answer came to me not as an emotion but as a timeline. 2 weeks earlier, I'd received a notice in the mail addressed to the estate of Margaret Hale, at my home address. It was from a storage facility across town. It said a unit was delinquent and would be auctioned if payment wasn't made within 7 days. My mother had never had a storage unit, not that I knew of, but the notice wasn't a generic scam. It had a unit number, a delinquency balance, and a signature line for the facility manager. I called the facility. I gave our mother's name. The woman who answered asked for my relationship. I said I was the court-appointed personal representative and offered to email proof. She said the unit was not in my mother's name. It was in Daniel's. But the alternate contact listed was Margaret Hale, and the billing address listed was Mom's masked apartment. That meant Daniel had opened the unit in his own name that used Mom's information to secure it. Either because he didn't want his own address in the record, or because he didn't want the unit tied to him if something went wrong. I asked the woman at the facility what was in the unit. She said she couldn't disclose contents, but she could tell me it had been accessed recently. I asked when. She said 2 days after my mother died. I asked if the access was recorded. She said yes, they logged gate entry and unit access using the key code and lock records. I asked if they could provide the logs. She said only to the account holder or by subpoena. I asked if the unit had been auctioned. She said no, the balance was paid the day after the notice was sent. I asked by whom. She said Daniel paid it online. I thanked her and hung up. At the time I didn't confront Daniel. I documented it. I made a note. I saved the notice. I logged the call. I saved the facility's email address. Because when people steal from family, they don't do it once. They do it until it costs them more to continue than to stop. Now Daniel was forcing the cost into the courtroom. I put on a suit that I kept for hearings and funerals. The suit wasn't for respect. It was for credibility. Courts don't say it out loud, but they notice when someone looks like they understand the seriousness of paperwork. I drove downtown. The courthouse parking lot was already filling. I walked through security and went to the probate division. The hallway outside the courtroom smelled like old carpet and coffee. People sat along the wall holding folders and staring at their laps. I checked in with the bailiff at the desk outside. The bailiff took my name and looked at a list. He said, "You're the personal representative." It wasn't a question. I said yes and handed him a copy of my letters testamentary. He glanced at it, nodded, and made a note. I sat down and waited. At 10:42, Daniel appeared at the far end of the hall with a man in a gray suit. His attorney. Daniel's suit looked new in the sense that it didn't fit like it had been worn before. His tie was too wide, his collar slightly crooked. He walked like he had rehearsed a posture in front of a mirror and couldn't maintain it while moving. He saw me and slowed. For a moment he looked like he might approach, but his attorney said something quietly, and Daniel kept walking. They sat on the opposite side of the hallway. Daniel didn't look at me again. He stared at the floor and tapped his foot. His attorney read through papers and occasionally leaned over to speak to him. Daniel's head nodded, but his eyes stayed fixed on something in the middle distance, like he was trying not to see the room he was in. At 10:55, the bailiff opened the courtroom doors. People filed in. I sat at the petitioner's table because Daniel's motion had named me as respondent. The attorney for Daniel sat at the other table. Daniel sat behind him. The judge entered at 11:03, a woman in her late 50s with glasses and a face that didn't soften for anyone. She didn't look angry. She looked careful, like someone who knows anger is noise. We stood. She sat. We sat. She called the case. Daniel's attorney stood and began speaking as though he had been practicing in an empty room. He said there was an urgent issue involving estate property being withheld. He said the estate was at risk. He said my brother, as personal representative, had attempted to obtain the property and had been refused. The judge held up a hand. "Before we do anything else," she said, "who is the personal representative in this estate?" Daniel's attorney hesitated. Then he said Daniel's name. The judge looked down at her screen and then at me. "Ms. Hale," she said to me, "are you the personal representative?" "Yes, Your Honor," I said. I stood and handed my letters testamentary to the bailiff, who passed them to the judge. She looked at them for 3 seconds. That was enough. She set them down. "Counsel," she said to Daniel's attorney, "your motion states your client is the personal representative. That is incorrect." The attorney said, "Your Honor, we were under the impression—" The judge cut him off. "You were under an impression that is contradicted by the docket you filed into." Daniel's attorney tried to pivot. He said that regardless of who held the title, there was property of the decedent being withheld. He said his client had a right as an heir. The judge said, "Heirs do not have self-help authority." That was the first procedural pressure point. The judge had identified the wrong foundation. Then she looked at Daniel. "Mr. Hale," she said, "stand up." Daniel stood. His face was neutral. His hands were held together in front of him like he was praying without intending to. The judge said, "Did you swear to this affidavit?" Daniel said yes. The judge said, "Did you read it?" Daniel said yes. The judge said, "It states you are the personal representative." "That is not true." Daniel's attorney said, "Your Honor, that was a mistake in drafting." The judge held up her hand again. "I'm not asking you," she said. "I'm asking him." Daniel's throat moved. He said, "I thought I was supposed to be." The judge said, "You thought you were supposed to be, so you swore under oath that you were." Daniel didn't answer. I didn't look at him. I looked at the judge, because the only person in the room with authority to change the outcome was not my brother. The judge turned to me. "Ms. Hale," she said, "what is the emergency here?" I opened my folder. "Your Honor," I said, "there is no emergency. The motion is based on false statements. The alleged safe deposit box is closed and has been closed for years. The claim that I removed property without notice is false. I have filed the inventory and I have documented distribution of personal effects in compliance with probate procedure." I handed the bailiff a packet of exhibits. The bank letter stating the safe deposit box was closed, the receipt, the inventory, and a copy of Daniel's signed waiver of notice for the appointment hearing he didn't attend. The judge skimmed the first page of the bank letter. Daniel's attorney said, "Your Honor, our information came from the decedent's statements to my client, and we have reason to believe there are additional assets not disclosed." The judge looked over her glasses. "What reason?" The attorney said, "There were references to jewelry and cash that the family believes existed." The judge said, "Beliefs are not evidence." Daniel's attorney said, "Your Honor, we request an order compelling her to produce all property and accountings." The judge said, "She is already required to account. She has filed an inventory. If you believe it is incomplete, you file objections with basis. You do not file an emergency motion with incorrect statements about authority." Daniel's attorney said, "There is also the issue of the trust binder." The judge looked at me. "Is there a trust?" she asked. "There was," I said. "It was revoked. I have the revocation document executed and notarized. It's filed as an exhibit in the initial probate petition." The judge tapped her pen once. "Counsel," she said to Daniel's attorney, "did you review the docket?" He said, "We reviewed portions of it." The judge said, "Review all of it. That is your job." Then she said something that shifted the room. "Mr. Hale," she said to Daniel, "why are we here today?" Daniel looked at his attorney. The judge said, "No, look at me." Daniel looked at the judge. His face tightened slightly around the mouth. He said, "She won't give me what Mom wanted me to have." The judge said, "What did your mother want you to have?" Daniel said, "Her jewelry. The things that matter." The judge said, "What jewelry?" Daniel said, "Her rings, her necklace. The cash she kept. The stuff she told me about." The judge leaned back slightly. "Ms. Hale," she said, "do you have those items?" "No, Your Honor," I said. "Some items were found and documented and are listed in the inventory. Anything not found is not in my possession." Daniel's attorney said, "Your Honor, we believe she's concealing it." The judge said, "Belief again." She looked at Daniel. "Mr. Hale," she said, "do you have any evidence that Miss Hale has these items?" Daniel's eyes moved. He said, "I know she does." The judge said, "How do you know?" Daniel said, "Because she took everything from the apartment." I said, "Your Honor, may I clarify that statement?" The judge nodded. 2 days after my mother died, I said, I went to her apartment with the landlord present because the lease required access. I photographed each room and documented personal effects. I removed only documents and items necessary for estate administration. The remainder was left until the family could review. Mr. Hale was notified by text message that day. I handed the judge printed copies of the photos with timestamps, and a copy of the text thread showing the message sent to Daniel and his non-response. The judge looked at the text. Daniel's attorney objected weakly, saying the photos could be incomplete. The judge didn't acknowledge the objection. She said, "Mr. Hale, did you receive this message?" Daniel said, "I don't remember." The judge said, "It is your phone number." Daniel said yes. The judge said, "Then you received it." She paused. This emergency hearing was set because the motion alleges irreparable harm and imminent loss. What imminent loss? Daniel's attorney said, "The estate assets could be transferred or dissipated." The judge looked at me. "Ms. Hale," she said, "have you transferred assets?" "Yes, Your Honor," I said. "I paid estate expenses. I paid funeral costs. I paid outstanding bills. All transactions are documented and can be accounted for." The judge nodded, as if confirming what the law already expected. Then she asked the question that made Daniel's foot stop tapping. "Mr. Hale," she said, "have you taken any of the decedent's property?" Daniel blinked. His attorney began, "Your Honor?" The judge said, "Not you." Daniel said, "No." The judge said, "No, you have not taken any property." Daniel said, "Not like that." The judge said, "Not like what?" Daniel's jaw tightened. He said, "I mean I have things that were mine already." The judge leaned forward. "Ms. Hale," she said, "is there any allegation that Mr. Hale has property?" "Yes, Your Honor," I said. And I felt the atmosphere shift because the room wasn't prepared for the accusation to reverse direction. I said, "I recently received a delinquency notice from the storage facility for a unit in Mr. Hale's name. The alternate contact was listed as my mother and the billing address was her apartment. The facility told me the unit was accessed 2 days after my mother died, and was paid current after I received the delinquency notice." Daniel's attorney stood quickly. "Your Honor, this is irrelevant and speculative." The judge looked at him. "It may be relevant," she said. "It may be the entire point." She looked at Daniel. "Mr. Hale," she said, "do you have a storage unit?" Daniel's face didn't change much at first. Then he swallowed. He said, "Yeah." The judge said, "What is in it?" Daniel said, "Just stuff." The judge said, "What stuff?" Daniel said, "My stuff." The judge said, "Is any of it your mother's property?" Daniel said, "No." The judge held his gaze. "Hale," she said, "you understand you are under oath." Daniel's attorney tried again. "Your Honor, we are here on his motion." The judge said, "And I am here on the truth. You brought me an emergency motion. You brought me an affidavit with false statements about authority. You brought me allegations of concealed property. I am not going to ignore the possibility that your client is using this courtroom to cover his own conduct." She paused and looked at her screen again. "This estate has been open for 6 months," she said. "There is an inventory, there are filings, there are bank letters, and suddenly we have a same-day motion alleging hidden cash and jewelry. Mr. Hale, did you file any objection to the inventory?" Daniel said, "I didn't know about it." The judge said, "You signed a waiver of notice. You have the same right as anyone to look at the docket. You choose not to participate, and now you claim emergency." Daniel's attorney said, "Your Honor, we request immediate access to the estate property, and if the court has concerns about the storage unit, we can address that separately." The judge didn't respond to that request. She said, "Ms. Hale, do you have the storage facility information?" "Yes, Your Honor," I said, and handed her the delinquency notice. The judge read it, then she looked at Daniel. "Mr. Hale," she said, "provide the location of this storage unit and the access code to Ms. Hale by noon today." Ms. Hale, you will inspect it with a neutral third party and report back. If there is estate property in it, it will be seized for the estate. Daniel's attorney said, Your Honor, this is beyond the scope. The judge said, No, it is within the scope of protecting estate assets. Then she turned to Daniel's motion. As for your request to freeze assets, she said, Denied. Daniel's attorney began to argue. The judge held up her hand, and the motion died in the air. Denied, she said again. Then she looked at Daniel. And Mr. Hale, she said, I am ordering you to file an amended affidavit correcting false statements. If you have made false statements knowingly, that has consequences beyond probate court. Do you understand? Daniel said yes. The judge ended the hearing. She didn't raise her voice. She didn't need to. The sound that mattered was the clerk typing the order into the record. We stood, and the judge left. Outside the courtroom, Daniel's attorney immediately started talking to him in a low voice. Daniel's head moved once in agreement. Then Daniel turned and walked toward me. He stopped about 6 feet away. That was his comfort distance, close enough to confront but far enough to retreat. He said, What are you doing? He didn't phrase it as a question. It was an accusation, as if I had done something improper by saying what I said. I said, I'm administering the estate. He said, You're making me look like a thief. I said, If there's nothing in the unit, the inspection will show that. He looked at me. His eyes held a flat anger, but his hands were shaking slightly. He put them in his pockets. He said, Mom wanted me to have those things, she told me. I said, Then you should have participated in probate. He leaned forward slightly. She told me where the jewelry was, he said. And it wasn't in the apartment because you got there first. I looked at him, and the thought that came to me was not about the jewelry. It was about how he needed to believe I had taken it, because the alternative was to admit he had. I said, You've had a storage unit in your name with Mom's address on it. He said, So. I said, The judge ordered you to give me access by noon. He stepped back a half step. He didn't deny the unit. He didn't deny the order. He shifted. He said, If you go in there, you're trespassing. It's my unit. I said, The court ordered the inspection. Bring your lawyer if you want. His mouth tightened. He said, You always have to make it official. I didn't answer that because it was the closest he could get to admitting the only thing that makes him nervous is a record. He turned away and walked down the hall. I left the courthouse and sat in my car. It was 11:38, noon was 22 minutes away. Time pressure is supposed to make people emotional. In my experience, it makes them reveal their hierarchy. People who are clean under pressure become efficient. People who are hiding something become frantic and start trying to negotiate with time itself. At 11:44, Daniel texted me. He wrote, Don't go to the unit, we can talk. At 11:46 he wrote, I'll bring you what you want. At 11:48 he wrote, Stop doing this. Those messages weren't apologies. They were attempts to remove the inspection from the system and bring it back into the informal space where he could manipulate it. I didn't respond. At 11:53 he texted an address. He added, Gate code is 3391. Unit is B17. No apology, no explanation, just compliance under threat. I called the storage facility manager and told her I would be arriving with a court order for inspection. I offered to email the order, but she said if I brought hard copies it would suffice, and that she would have someone present. I also called a locksmith I had used once before when my mother locked herself out. He answered on the third ring. I asked if he could meet me at a storage facility in 30 minutes, and open a unit if the lock was changed. He asked if it was legal. I said I had a court order. He said text me the address. I did. Then I called a retired neighbor of my mother's, a man named Mr. Jensen, who had known our family for years, and had a way of observing without inserting himself. I asked if he could come as a witness. He said yes. He didn't ask why. He understood what a witness is for. I drove to the facility. The address Daniel sent was real. The gate code worked. When I entered, the camera above the keypad tilted slightly as it tracked the car. I noted it. Cameras are silent witnesses, and they are hard to intimidate. I parked near the office. The manager came out with a laminated badge and a clipboard. She looked tired, like she had seen family disputes turn into police calls before. I handed her the court order and my letters testamentary. She read them. She nodded. I'm not letting you take anything without documenting, she said. That's what I want, I said. She led us down a corridor of metal doors. The air smelled like dust and hot metal. Unit B17 was in the middle. There was a padlock on it. It looked newer than most. The manager said, "This lock isn't ours, it's the tenant's." I said, "I don't have a key." She said, "We can cut it if you have authority." I showed her the order again. She nodded and called for maintenance. Mr. Jensen arrived as we were waiting. He stood slightly behind me, his hands folded, his eyes taking in everything without saying anything. The locksmith arrived at 12:29. He looked at the order. He used bolt cutters. The lock fell to the concrete with a sound that was final. The manager lifted the door and rolled it upward. What was inside wasn't a simple pile of stuff, it was organized. There were plastic bins labeled in black marker. There were 2 garment boxes. There were framed photographs in bubble wrap. There was a long rectangular case that I recognized immediately from my mother's closet years ago. Her jewelry case, and there against the back wall was a small fireproof safe with a dial. The manager looked at me. "You want me to make an inventory?" she asked. I said. She took out forms. She began listing items as she saw them. Mr. Jensen wrote his own notes on a notepad he had brought. The locksmith stood by, waiting. I stepped into the unit carefully, because chain of custody isn't just for evidence rooms. It's for any moment when someone might later claim you planted or removed something. I opened the nearest bin. Inside were my mother's papers, old tax returns, bank statements, medical records, things she would never have given Daniel to store because Daniel didn't keep paper, he lost it. Another bin contained silverware wrapped in cloth. I saw my mother's handwriting on a small label taped to a bundle. Wedding set. I didn't open the bundle. I didn't need to. The label itself was evidence of intent. She had packaged it with that name. I looked at the jewelry case. It had a latch. I didn't open it yet. The manager kept writing. Then I moved toward the safe. The locksmith asked, "You got the combination?" "No," I said. He looked at the dial. "You want it opened?" "Yes." He asked, "You sure you want to do that here?" I said yes, everything gets documented. He knelt and began working. As he did, I noticed something that made the situation more than just theft. On the top of the safe was a small digital voice recorder, one of those thin black ones with a slider switch. I recognized it because I had bought it for my mother 2 years earlier after she told me she was worried Daniel would twist what she said. I had shown her how to use it. I had told her to record any conversations that mattered. She laughed at the idea and then quietly she thanked me. I picked it up carefully. The switch was in the off position. I turned it over. The back was scratched. It looked used. The manager glanced at it and wrote, "Digital recorder, black." Mr. Jensen's pen paused, then continued. The locksmith clicked his tongue and said, "Got it." He turned the dial and opened the safe. Inside were 3 things. A thick envelope sealed with tape, a small velvet bag, and a spiral notebook with a rubber band around it. I looked at the envelope. On the front, in my mother's handwriting, was written, "For court, if needed." I didn't open it yet. I looked at the notebook. The cover was plain. On the first page, visible through the spiral, was a list of dates and amounts. It looked like a ledger. I looked at the velvet bag. I didn't open it. The manager wrote each item down with more care now, because she felt the shift. She wasn't just watching someone clean out a unit, she was watching a record being created in real time. I asked her if the facility could provide gate logs showing entry times. She said yes, but only to the account holder or by subpoena. I said, "The court order is an order in probate." She shook her head. "Our policy is subpoena for logs." I nodded. "Then I will subpoena." I didn't argue. Policies are like locks, you don't shout at them. You apply the correct tool. We finished the inventory. The manager made copies. She signed. I signed. Mr. Jensen signed as a witness. We loaded the bins and the safe contents into my car with the manager watching. The locksmith relocked the unit with a facility lock. The manager said she would note in the file that the unit had been opened under court order and the contents removed pending further instruction. I drove home with everything in my trunk. I drove carefully, not because I was worried about the value of what was there, but because I was carrying the physical proof of Daniel's lie, and I didn't want a car accident to turn a clear case into a messy one. When I got home, I placed the items on my dining table. I set up my phone on a tripod and began recording video. Not for drama, for documentation. I filmed each bin and its contents as I opened them. I spoke only in factual terms. Bin 1, papers. Bin 2, silverware. Bin 3, photographs. I filmed the jewelry case. I filmed the safe items. I filmed the voice recorder, showing its serial number. Then I opened the velvet bag. Inside were rings and a necklace. Not costume jewelry. Not modest items. The kind of pieces you keep because they carry history. And also because they carry money. I looked at them and felt something I didn't name. I didn't need to. The record would say enough. I opened the envelope labeled for court if needed. Inside were 2 documents and a small USB drive taped to the paper. The first document was a handwritten letter from my mother, dated 8 months before she died. It was addressed to whom it may concern. It stated that Daniel had taken property from her home without permission, that she feared he would attempt to control her finances, and that she had moved certain items for safekeeping. It named the storage unit by address and unit number. She wrote in the same careful script she used for grocery lists. If Daniel claims he is entitled, he is lying. If he says I told him, I did not. I am recording our conversations now because he denies what he does. The second document was a notarized statement revoking any prior informal promises. It confirmed I was to serve as executor and that Daniel was not to have access to accounts. The USB drive had a label, Recorder Backup. I sat back in my chair and looked at the voice recorder again. That was the escalation Daniel didn't anticipate. He thought he could keep the fight in the realm of she took it. No, he took it. He thought it would be a family argument. He didn't realize our mother had turned it into a file. At 3:12 p.m. Daniel called me. I let it ring. Calls are useful but only when you can control the record. At 3:13 he called again. I answered and put it on speaker with my phone recording video. He said, "You went in there." "Yes," I said. He said you had no right. "The court ordered it," I said. He breathed hard, controlled like he was trying to keep his voice steady. He said, "You took my stuff." "I took estate property," I said. He said, "That jewelry was for me." I said, "We'll address distribution through the court." He said, "Don't do that. We can handle it." I said, "It is being handled." He paused, then tried a different angle. He said, "You don't understand. Mom didn't want it like this." I said, "There's a letter in the safe addressed to the court." Silence. I could hear his breath change. He said, "What letter?" I said, "The one she wrote for this." He didn't speak for a few seconds. Then he said, "Don't show that to anyone." I said, "It's part of the estate file." He said, "She was sick. She didn't know what she was saying." I said, "The letter is dated 8 months before she died." He said, "Just listen, we can split it, we can make it fair." I said, "Fair is what the law requires, not what you propose after you get caught." His voice hardened. He said, "You think you're better than me because you have paperwork." I said paperwork is the only thing that doesn't change its story. He hung up. That evening I drafted a filing. It wasn't emotional. It was a report to the court that pursuant to the emergency order, I had inspected a storage unit in Daniel's name and found estate property. I attached the facility inventory sheet, photographs, and my mother's letter. I also filed a motion for sanctions, and for an order requiring Daniel to return any additional property, and to account for estate assets he had taken. At the same time, I prepared a subpoena for the storage facility gate logs. The gate logs would show Daniel's entry times, including the day 2 days after our mother died. It would also show if he had been there after the delinquency notice. I filed a request for a hearing. The clerk scheduled it for 2 weeks later. 2 weeks is a long time when someone is hiding things, but it was the earliest available date. That night, I didn't sleep much, not because I was thinking about jewelry, but because I was thinking about what else Daniel had touched. My mother's papers in the storage unit included bank statements. I flipped through them. I saw withdrawals that didn't match her spending patterns, cash withdrawals in amounts she never used, transfers to accounts I didn't recognize. I knew the bank. I recognized the branch code on the statements. The withdrawals happened in person. I opened my laptop and logged into the estate bank account that I had moved the funds into after her death. The balances were correct now, but the history showed gaps I hadn't examined closely enough because I had trusted that our mother's final months had been quiet. They hadn't been quiet. The next morning, I went to the bank with my letters testamentary and requested historical statements and copies of any documents associated with account access changes. The bank manager, a man named Patel, brought me into an office. He said, "We usually require a specific request." I said, "I am requesting any change of address forms, any authorized signer forms, any power of attorney documents, and any records of access to the safe deposit box." He said, "The safe deposit box is closed." "I have a letter confirming that," I said. "I also have a court hearing pending, and evidence of misappropriation." His face shifted from routine to cautious. "Banks respond to liability. He asked if I had a police report. I said, "Not yet, I'm building a record." He nodded slowly and said he would submit an internal request. Then he asked a question that told me the bank already suspected something. "Did your mother ever have a power of attorney on file here?" he asked. "Yes," I said. "She executed one naming me, but I did not submit it because she handled her own affairs until close to the end." He looked at his screen. He said, "We have a power of attorney on file naming Daniel." The room went quiet in the way it does when something becomes criminal. I said, "That is not possible." He said, "It's on file. It was submitted 11 months ago." I asked to see it. He said he couldn't provide a copy without a formal request, but he could show me the metadata. He turned the monitor slightly and pointed. Submitted by Daniel Hale. Processed by Branch Employee ID. Type, Durable Power of Attorney. Date received, 11 months ago. I said, "My mother did not execute that." He didn't argue. He didn't confirm. He said, "If it's fraudulent, we need to escalate." I said, "Yes." I left the bank with a written confirmation that a POA naming Daniel was on file, the date received, and the branch employee who processed it. I requested a certified copy through formal channels. I drove straight to the courthouse and filed an emergency motion again, this time mine. I requested an immediate hearing for suspected fraudulent POA submission and misappropriation. The hearing was set for the next day at 9 a.m. Daniel had created procedural pressure by filing an emergency motion. Now the pressure was on him, but it wasn't my voice doing it. It was the court calendar and the bank's compliance process. The night before the hearing, I listened to the voice recorder. The first recording was 3 minutes long. It was my mother's voice and Daniel's recorded in her kitchen. The date stamp showed 10 months before she died. Daniel's tone was casual, like he was asking for something ordinary. He said, "Just sign it, it's so I can help you." My mother said, "I'm not signing anything you bring me without reading it." Daniel said, "It's just a power of attorney. You already said you wanted me to handle stuff." My mother said, "I did not say that." Daniel said, "You did." My mother said, "No, and you know I didn't." Then a rustle, paper moving. Daniel said, "Look, if something happens, Sarah will take everything, you know that." My mother said, "Sarah is the one who shows up." Daniel said, "She shows up to control you." My mother said, "She shows up because you don't." Then Daniel's voice hardened slightly. He said, "You're going to regret this." My mother said, "Stop talking to me like that in my house." The recording ended shortly after. There were more recordings, some longer, some with silence where my mother had left the recorder running. One included Daniel saying, "Nobody checks these things at the bank," followed by a laugh that didn't sound amused. It sounded contemptuous. I saved copies of the recordings to my laptop. I kept the original recorder sealed in an evidence bag I bought online for $10. Evidence bags aren't magical, but they send a message to the court. I understand what this is. The next morning, Daniel appeared in court again, this time with the same attorney, but his posture was different. He looked like someone who had slept badly, not from guilt, but from strategy failing. The judge entered, same measured face. She called the case. I presented the bank manager's letter, confirming a POA naming Daniel on file and the date. I presented my mother's recorded statements. I didn't play them yet. I told the judge I could if needed. Daniel's attorney objected, saying recordings could be manipulated. The judge looked at him. "Then you can hire an expert," she said, "but you will not dismiss them without basis." Daniel's attorney said, "Your Honor, my client denies any wrongdoing. He was trying to help his mother." The judge said, "Then why is property in a storage unit in his name funded by payments he made, containing items labeled in the decedent's handwriting as, 'for court'?" Daniel's attorney tried to say the items were stored for convenience. The judge looked at Daniel. "Mr. Hale," she said, "did your mother authorize you to remove her property and store it in your unit?" Daniel said, "She wanted it safe." The judge said, "You filed an affidavit stating your sister took everything. Now you say you took it for safekeeping." Daniel's jaw tightened. He said, "I didn't take it. She gave it to me." The judge said, "If she gave it to you, why is there a letter stating you took it without permission?" Daniel's attorney said, "Your Honor, we haven't seen this letter before." The judge said, "You will see it now." She read from my mother's letter out loud, not the whole thing, just the sentence that mattered. "If Daniel claims he is entitled, he is lying." Daniel's face went still. It was not a dramatic reaction. He didn't flinch, his eyes didn't widen. His skin simply lost color, like his body had decided it no longer needed to keep pretending. The judge ordered a forensic review of the alleged POA on file with the bank. She ordered the bank to produce the original document and submission records. She ordered Daniel to cease any contact with estate assets. She also referred the matter to the county prosecutor's office for review of potential fraud. Daniel's attorney objected to the referral. The judge said, "I am not making a criminal finding. I am making a referral based on evidence presented in my courtroom." Then she set a full evidentiary hearing for the following month. That was the institutional entry Daniel didn't account for. Probate court is quiet until it isn't. Once a judge suspects fraud, the case moves from family dispute to system integrity. Judges care about heirs, but they care more about the integrity of their process. Over the next 2 weeks, more records arrived. The storage facility produced gate logs under subpoena. The logs showed Daniel's code entering at 6:41 a.m., 2 days after our mother died. Another entry at 8:13 p.m. the night before his emergency motion. Another entry the morning after I received the delinquency notice. The bank produced a copy of the POA. It was a durable power of attorney form, with my mother's name typed, and a signature at the bottom that looked like hers if you glanced quickly, and like a forgery if you compared it to her actual signature on her will. There was a notary stamp. The notary's name was printed, but the commission number was partially illegible. The bank also produced teller logs showing Daniel had requested cash withdrawals from my mother's account 3 times in the last year, withdrawing $5,000 each time. The teller notes included, "Customer present, no, POA used." My mother had not been present. Daniel had been using a POA to drain her account while she was alive. I filed these documents with the court as supplemental exhibits. Daniel's attorney filed a response claiming the signature was genuine and the recordings were taken out of context. He also filed a motion to exclude the recorder on the grounds of privacy. The judge denied the motion to exclude, noting that the recordings were relevant to intent and that the decedent's own recordings of conversations in her home did not violate Daniel's rights in the context of probate proceedings. She reserved final admissibility for the evidentiary hearing. The case now had momentum, but Daniel still had one tool left: delay and confusion. He tried to muddy the record by filing additional motions, claiming I was harassing him with subpoenas, claiming the storage unit had mixed property, claiming the ledger in the safe was her notes about gifts. He also did something that forced the timeline forward. He stopped paying his attorney. I learned this not from gossip but from a filing. Daniel's attorney moved to withdraw due to non-payment. The motion was set for the same day as the evidentiary hearing. That meant Daniel would either represent himself or hire someone else at the last minute. Last-minute counsel rarely helps because they don't have time to invent a coherent story. They have to deal with the record as it exists. The evidentiary hearing began at 9 a.m. on a Tuesday. I arrived early with 3 binders, one for the judge, one for Daniel, one for myself. Each binder contained a table of contents and numbered exhibits. It wasn't flashy, it was clean. Daniel arrived alone. No attorney. He wore the same suit, but it looked less new now, wrinkled at the elbows. He avoided my eyes. The judge entered. The bailiff called the case. The judge first addressed the withdrawal motion. Daniel's attorney was present briefly, explained the non-payment, and the judge granted the withdrawal. Then he left. Daniel was now on his own. The judge looked at him. "Mr. Hale," she said, "you understand you are representing yourself." Daniel nodded. The judge said, "This is an evidentiary hearing. Evidence will be admitted. Witnesses may be called. You will be held to procedure." Daniel nodded again. Then the judge looked at me. "Ms. Hale," she said, "proceed." I stood. I began with the simplest fact. I was personal representative. I had filed the inventory. Daniel had filed an emergency motion with false statements. The storage unit inspection had revealed estate property. The bank had produced a PLA naming Daniel, likely fraudulent. The recordings indicated coercion and awareness. I offered exhibits into evidence. The judge admitted them one by one. Then the judge called the first witness, the storage facility manager. She testified by phone. She confirmed Daniel rented the unit. She confirmed access logs existed. She confirmed the unit was accessed 2 days after our mother died, and again the night before Daniel filed his emergency motion. Then the bank manager testified. He confirmed a POA was on file. He confirmed it was submitted by Daniel. He confirmed withdrawals were made under POA authority. Then I offered the recordings. The judge looked at Daniel. "Any objection?" she asked. Daniel swallowed. He said, "She recorded me. That's not fair." The judge said, "Fairness is not the standard. Relevance and authenticity are." I played a short clip. Daniel saying, "Nobody checks these things at the bank." The sound in the courtroom was small, tinny from my speaker, but it landed hard because it was Daniel's own voice speaking. The truth he couldn't say now. Daniel stared at the table. Then I offered the ledger found in the safe. I explained that it contained a list of withdrawals and notes in my mother's handwriting, documenting the dates she noticed money missing and the times Daniel visited. The judge looked through copies of the ledger pages. Daniel said, "That's not what it is." The judge said, "Then what is it?" Daniel said, "She wrote things down because she was paranoid." The judge said, "Or she wrote things down because she was documenting." I thought the hearing would end with those exhibits. I thought the record was already enough. But the system has a way of tightening its own grip once the lie becomes measurable. The judge said, "Bailiff, bring in the inventory." I didn't understand at first. Then the bailiff left and returned with a man in uniform carrying a file. This man wasn't the courtroom bailiff. He was from the sheriff's civil division. The judge addressed him. "Deputy," she said, "you executed a writ in this matter." He said, "Yes, Your Honor." That was new to me. I hadn't requested a writ. Then I realized what had happened. After the first emergency hearing, when Daniel refused to voluntarily return items, I had filed a standard motion for turnover. The court had issued an order authorizing civil enforcement if necessary. I had sent the order to the sheriff's civil division, expecting a slow process. It hadn't been slow. While we were building evidence, the sheriff had already acted. The deputy stepped forward and handed the judge a document. The judge looked at Daniel. "Mr. Hale," she said, "the sheriff executed a writ of seizure on your storage unit and your residence last week based on the court's turnover order and evidence of estate property being withheld." Daniel's head lifted sharply. He said, "What?" The judge didn't repeat herself. She said, "The deputy has an inventory of items seized." Then she turned to the deputy. "Read it into the record," she said. That was the moment from the title, but in the room it didn't feel like a climax. It felt like an audit. The deputy opened the file and began reading, in a flat voice that didn't care about family dynamics. Item 1, fireproof safe, black, serial number noted. Item 2, jewelry case, wood, containing assorted rings, necklaces and bracelets, photographed. Item 3, envelope labeled for court if needed, containing handwritten letter, notarized statement, and USB drive. As the deputy read, I watched Daniel's face, his eyes fixed on the file as if he could stop the words from existing by staring at them. His skin paled further when the deputy reached the items that Daniel hadn't known the sheriff would find. Item 7, laptop computer silver, Apple brand, seized from residence, logged as evidence. Item 8, file folder labeled POA, containing unsigned blank power of attorney forms and notary stamp impressions on scrap paper. Daniel's mouth opened slightly, then closed. The deputy continued. Item 9, cash, U.S. currency, $12,400, found in shoebox in bedroom closet. Item 10, checkbook in decedent's name, account ending 4412. Item 11, notary stamp, name E. Navarro, commission number. The deputy paused to read the number. The judge's eyes lifted from her screen to Daniel. Daniel looked like he was trying to keep his body still. His hands gripped the edge of the table. His knuckles whitened. The deputy continued. Item 12, digital voice recorder, black serial number noted. I already had the recorder, but the sheriff apparently seized a second one from Daniel's residence, which meant he had taken my mother's original and perhaps made copies or attempted to remove recordings. The deputy read the last items. The list was long, and each item was another piece of the record sliding into place without needing my interpretation. When the deputy finished, the courtroom was quiet. The judge looked at Daniel for a long moment. Then she said, "Mr. Hale, do you have any explanation for why the sheriff seized blank POA forms and a notary stamp from your residence?" Daniel's voice came out small. "I don't know." The judge said, "You don't know why a notary stamp was in your closet." Daniel said, "I don't know." The judge said, "Do you know a notary named E. Navarro?" Daniel said, "No." The judge looked at the deputy. "Deputy," she said, "did you verify the notary commission?" The deputy said, "Yes, Your Honor, the commission number is expired." The judge nodded once as if confirming what she already expected. Then she turned back to Daniel. "Mr. Hale," she said, "your conduct is not a probate dispute. It is fraud. It is theft. It is abuse of the court's process." Daniel tried to speak, but nothing coherent came out. He said, she, The judge said no. Not loud, just final. She looked at the clerk. I am issuing findings on the record, she said. I find that Mr. Hale filed a false affidavit, that he misrepresented his authority, that he concealed and retained estate property, and that the evidence supports referral for criminal investigation. She ordered immediate turnover of all seized items to the estate. She ordered restitution of withdrawn funds to the estate pending criminal proceedings. She imposed sanctions for the emergency motion filed in bad faith, including attorney fees I had incurred responding. Then she addressed the bank manager, still on the line. Mr. Patel, she said, the bank will freeze any access under the POA naming Mr. Hale immediately and will cooperate with law enforcement. He said, yes, Your Honor. She then looked at me. Ms. Hale, she said, you will file an amended inventory reflecting recovered property and any additional accounts discovered. You will continue administration under supervision. You will not distribute the jewelry until this matter is resolved. I said, yes, Your Honor. The judge looked at Daniel one more time. Mr. Hale, she said, you are ordered not to contact Ms. Hale except through counsel. If you violate that, you will be held in contempt. Daniel nodded mechanically. The hearing ended. Outside the courtroom, Daniel stood alone in a hallway. People passed him without looking. He looked smaller than I remembered, not because he had changed physically, but because his sense of power had been tied to secrecy, and the secrecy was gone. He didn't speak to me. He didn't have anything left that would work. 2 days later, a detective called me from the county prosecutor's office. He asked for copies of the recordings and the bank documents. I provided them. He asked for the ledger. I told him it was in the sheriff's custody. He said he would request it. A week later, I received a notice that Daniel had been charged with forgery and theft. The charges were separate from probate, but they were built from the same record. The probate case continued quietly after that, because once fraud is exposed, the remaining work becomes administrative. I filed an amended inventory. I listed each recovered item. I listed the cash recovered and deposited into the estate account. I listed the jewelry and its appraised value. I listed the safe contents and the documents. I also filed a final accounting of legal expenses, including the cost of subpoenas, copying, and travel. The judge approved reimbursement from the estate, with the understanding that restitution would be sought from Daniel. None of it felt like revenge. Revenge requires emotion. This was something else. It was a system correcting a false entry. Months later, I received a signed order closing the estate, contingent on the criminal case. The estate assets were secured. The jewelry was placed in a court-approved safe deposit box in my name as personal representative, with dual access requirements. The bank account was stable. The record was complete. Daniel didn't speak to me again. He sent one email through a public defender asking if we could work something out. I forwarded it to the prosecutor and my probate counsel and didn't respond. That was the calm procedural aftermath. Not reconciliation. Not a dramatic final confrontation. Just a quiet refusal to step outside the record again. There are people who still ask why I didn't handle it privately. They say family should be handled within the family. They say court is extreme. But court is what you use when someone relies on silence. Daniel relied on me being reluctant to make things official. He relied on me not wanting to embarrass him. He relied on the fact that most families will absorb theft because they don't want the story attached to their name. He misjudged our mother. She didn't fight with emotion either. She fought with documentation. She wrote, she recorded, she labeled an envelope, for court if needed, and then made sure it would be found. The bailiff reading that inventory list aloud in court wasn't theater. It was the point where the system finally spoke in the only language Daniel respected: itemized, numbered, signed. That's what ended it. Not my anger, not my arguments, not even my grief. A storage facility gate log, a bank teller record, a notary commission number, a recorder timestamp, a deputy's inventory sheet. Systems and records don't care who you are to each other. They care what you can prove. If you've dealt with a situation where someone tried to weaponize family and use institutions as cover, you already know how isolating it can feel before the record catches up. If you want to share your experience or ask how I structured the documentation, you can leave a comment. If you want more stories like this, where the power shifts through procedure, not volume, you can subscribe.